Good morning. I'm Paul Truster, Program Planning Lawyer for the Law Society's Department of Continuing Legal Education, and on behalf of the department, I'd like to welcome you all to today's program, Sealing 6000, the New Small Claims Court. I'll begin by apologizing for the renovations outside the east entrance, which you no doubt noticed. I trust you all made it in safely and that no small claims court claims will arise against the Society as a result. I'll begin by thanking today's volunteer faculty, not all of whom obviously are in place yet on the podium, but as you know, CLE is a nonprofit and completely dependent upon the efforts of our volunteer faculty who have given so generously of their time and talents, both in preparing for this program and in presenting it. And you all have our sincere thanks. It gives me great pleasure now to introduce the co-chairs of today's program, who are both, no doubt, already well known to many of you. His Honor Judge Marvin Ezuker was appointed Provincial Court Judge in 1978 and has been a member of the Civil Division Advisory Rules Committee since its inception. He was appointed to the Family Court in 1990 and has lectured extensively at the Ontario Institute for Studies in Education and York University. He has also authored or co-authored several books, most recently the Small Claims Court Practice volume, which, as I say, most of you have. Richard Soderberg holds the position of Coordinator, Small Claims Court, Program Development Branch within the Court's Administration Division of the Ministry of the Attorney General. In addition, he has served as clerk of the Richmond Hill Small Claims Court, the North York Small Claims Court, and the Etobicoke Small Claims Court. In his current capacity, he's played a key role as a member of the project team which was responsible for both the conversion of the Small Claims Court staff to the public service and, in addition, the increase in the monetary jurisdiction of the Small Claims Court to $6,000 province-wide. And he's also an active member of the subcommittee of the Civil Rules Committee responsible for recommending changes to the rules of the Small Claims Court. Please join me in welcoming our chairs. Thank you.
It gives me a great pleasure to be here this morning. One person, unfortunately, who isn't here that I think I would be remiss in mentioning to some of you, if you don't recall him, would of course be Doug Turner, who was the first and only Chief Judge of the Civil Division. And I think Judge Turner was certainly as involved as any person in the growth and the creativity and development of the Small Claims Court. So I simply wanted to mention him because I know we often think of him from day to day. After being appointed to the Small Claims Court in 1978, and I think being told at the time that the jurisdiction would be increased around the corner, although it has been a long corner, it's certainly welcome news, I'm sure, to all of us that the jurisdiction, the monetary jurisdiction of this court was increased on April 1st of 1993 to $6,000 throughout the province of Ontario. I noted Mr. Levitt, Howard Levitt's column in the Star this week, who talked about wrongful dismissal and suing in small claims court. And one correction from his column, of course, is the fact that it's $6,000 throughout the province and not in parts of Ontario. Although some of us from time to time may think that the Metropolitan Toronto may be the only part of Ontario, that in fact is not the case. Interestingly enough, I've always thought that the confidence in the administration of justice comes not from the larger cases, but from the smaller ones. Because it's the smaller cases in terms of monetary amount that most people are involved with. And certainly statistically, some 80% or 85% of all civil actions in Ontario have been heard in small claims courts, and I wouldn't be surprised if that amount increases with the ceiling being increased to $6,000. The courts, of course, are intended to provide accessibility to members of the public. And I think as well the court has provided a teaching ground or a learning ground for a lot of people who have grown into the judicial system, i.e. As an articling student and then as a lawyer or as a law clerk or in various functions. So it's certainly a learning process and again provides accessibility, I think, to the public. In that regard, I would think and hope over the next several weeks and months that the Small Claims Subcommittee that will be looking at the rules may well look at night court in terms of increasing the jurisdiction of night court. I think the reality is that so many people that use these courts, if not most of them, cannot afford to take time off work. The issue, of course, is that at the present time, generally night court is restricted to non-reportable cases up to $500 in most jurisdictions. But arguably, there's no reason why the non-reportable amount could not be increased to $1,000 or $2,000, or alternatively, as they do in some American jurisdictions, hear cases up to $6,000, and the lawyers themselves might agree to pay the costs of the court reporters, which might be relatively negligible. But I don't see any reason why night court matters within time constraints, obviously, should not or could not increase the amount in terms of monetary jurisdiction in terms of the cases they hear. Rule 102 or sub-rule 102 of the rules, I suppose, sets the tone for the general principle of interpretation, and that is these rules shall be liberally construed to secure the just, most expeditious, and at least expensive determination of every civil proceeding on its merits in accordance with Section 25 of the Courts of Justice Act. And that states that the court, small claims court, shall hear and determine in a summary way all questions of law and fact, and may make such order as considered just and agreeable to good conscience. I remember when I was sitting in small claims courts, one of the things that used to make me cringe was when a lawyer came in and said, well, this isn't important, or that's not important, or the law is not important because it's just small claims court. I think the reality, obviously, is that small claims court is a court of law. And it's a court where you've got court reporters. It's an appealable court. Matters are appealed to the divisional court. They're appealed possibly thereafter to the Court of Appeal. So in every sense, the small claims court is a court of law. It's not just small claims court. The other thing I find or found over the years that for a lot of people who hadn't used small claims courts, and I think this will obviously change in the future, is the reality that many individuals did not realize that small claims court had its own set of rules. In fact, lawyers quite often refer to the rules of practice without realizing, again, that there were a set of rules that apply to small claims courts. I think in that regard, however, one of the sub-rules provides to an analogy to the rules. And you'll find if you look at the small claim court rules, the obvious thing is they are not as extensive in any stretch of the imagination as in the rules of practice. And that what I often did, and you may choose to do, is that where a specific issue is raised that you may be dealing with that is not covered by the small claim court rules, there's no reason why, by analogy, you cannot refer to the specific rules and the rules of practice. Because again, there is considerable difference in the number of rules and the issues and matters that are covered in the small claim court rules vis-a-vis those in the general division. Now, I talk about initially, of course, starting an action, and everyone knows you start an action by means of a claim. I refer in the paper to a claim being set out with respect to one short opening paragraph. I mention that because I often found that when I looked at the length of a claim, and then ultimately the person that prepared the claim came into court, I found a general relationship or direct correlation between the length of the claim and the younger the person was that was in the court. Usually it was the articling student who had just come out of law school, I guess who had been taught that more the merrier. But if you generally find a claim that's several pages long, that you have several pages attached to the claim form, it may invariably come from an articling student. I only say that, maybe I shouldn't say this, perhaps they have more time than others. But I simply found that they were quite long. I don't know that you need the kind of detailed analysis, and probably you don't, that you use in the general division. Our courts, of course, provide for service of a claim and for service of documents through the bailiff of the court. As you know, lawyers can arrange for service directly as opposed to the bailiff serving papers. In some cases, and that's something you can decide for yourselves, it may be faster, in quotation marks, to have it served through a private process server rather than the bailiff of the court. Again, that depends on the court you're in, depends on how long you anticipate service may take, and how fast you want the matter to proceed. A defense, of course, can or cannot include a counterclaim. I say this because a lot of people simply include the counterclaim within a defense rather than filing a separate document. And again, in terms of counterclaim, keep in mind the different terminology between the things such as a counterclaim and what is used in the general division and the rules of practice. One of the things I think you find in small claims court, and I allude to this on page 6 of the paper, I use the word inquisitive. There are a few typographical errors in the paper. I'm not sure whether this is one of them, but what I meant to say was that you will find quite often that the judge in a small claims court performs more of an inquisitorial method rather than the adversarial method of conducting a trial. Because quite often, one of the parties is unrepresented. Some lawyers may take the position or may feel that it's usually the unrepresented litigant that the judge seems to be favoring because he or she is not represented. I'm not sure that that's the case, but certainly where you've got both parties unrepresented, and to some extent where one party is represented and one is not represented, the judge may to some extent take over the case simply because, again, you have an unrepresented litigant who presumably is not an institutional plaintiff to the extent that they're not familiar with the process. I'm not sure necessarily that the unrepresented litigant, either by watching Perry Mason or Judge Wapner, who is now retired, I understand, although he may continue to get royalties. But I'm not sure that by watching that show you necessarily present what has to be presented in court. And in fact, as I will come to the pre-trial process, and I think I'm jumping ahead here a little bit, but the pre-trial process, to me, has always been an area where things get evened out. I say evened out in the sense that when you're dealing with an unrepresented litigant, the reality, again, is that most cases, if not many cases, may not be pre-tried. You need individuals, of course, that will pre-try these cases. I don't know with government restraint whether more people will be appointed to hear pre-trials. I might make the assumption they will not be. But of course, under our rules, you can apply for a pre-trial. I say the pretrial process, and I'll come to it in a few minutes, is important because it gives the pretrial judge or deputy judge the opportunity to really correct a lot of the matters that need to be corrected. It used to be that whenever you wanted something quote-unquote to be corrected, or there wasn't enough information to defend the matter, or your client was the wrong person being sued, or someone was being sued who should not have been sued, you'd have to bring a motion. Now, as some of you are aware, this is not necessary any longer because a pretrial judge or deputy judge, or perhaps in some cases referee, can endorse on the record, or in the case of a referee, recommend that the record be endorsed to deal with all of the issues that you would have otherwise had to bring a motion for. So I think a lot of things can be corrected, and certainly instead of perhaps coming to trial and having the matter be adjourned simply because someone doesn't know what they have to do or didn't do what they should have done, all of these things can be corrected at pretrial. So I think myself that if there's any singularly important process within this process, it's the pretrial process. I mentioned before the issue of the unrepresented litigant to some extent being unfamiliar with the rules. And Rule 19 that talks about service of documents within 14 days of trial, and if service is not provided, the documents may be inadmissible, I should say. The reality is a lot of people will come to court. They will not have provided the other side with documents within the 14 days, and you may have to grant an adjournment with or without cost. But again, that is the kind of thing that could be resolved at a pretrial. Some judges and some individuals that hear small claim court cases may take the position that if you attach all of the relevant documents to your claim, in other words, all the documents you intend to rely upon at trial, not only simply a contract, if the claim is based on a contract, then that could be hypothetically service for the purposes of Rule 19. Others don't take that position. But certainly if you have documents, a safe way, I suppose, and an easy way would be simply to attach the documents to the claim and have all the documents served on the defendant or defendants with the claim. Rule 2 is an important rule, and this is a rule that some people may or may not be familiar with, and that is basically under our rules, there's no such a thing as a nullity. At the very most, non-compliance with the rules is an irregularity. In other words, anything, virtually and everything, can be amended. Rule 202 states that the court, Rule 202 allows the court to dispense with the any rule compliance at any time in the interests of justice. Now, non-compliance may have attached with it some issue of cost, but I think that rule is significant. And again, as I mentioned on pages 8 or 9, it's unlikely, it certainly was unlikely with myself, that I would ever strike a pleading as being defective. I think the safer route is to, if you have to bring a motion for particulars rather than a judge asking the judge to throw out the claim itself. And I mentioned on page 9, a pleading may be struck out if it is scandalous. Nothing is scandalous, however, which is relevant. And the test of whether the allegation is relevant to the cause of action is whether the allegation is relevant to the cause of action or defense. The issue of discovery historically in this court has been basically a non-issue. But I think the reality may be, with the jurisdiction being increased to $6,000, and as well I would think the reality that individuals with $7,000 or $8,000 or possibly $9,000 or $10,000 actions that may have been commenced in the general division, and I say may have been commenced in the general division because, as you can appreciate under one of our rules, you can apply to, if any of you have matters now in the general division, you can apply to transfer these matters down to the small claims court on consent. And I suppose arguably, well, you can apply to have them transferred down. I think the other thing is that because of the amount involved, I think there's going to be more requests for discovery. And the issue will then be, of course, again, the issue of cost, because I think it is still, quote unquote, a small claims court, and I think the bottom line is one wants to keep costs as minimal as possible. I mentioned the issue of pretrials, and certainly I talk on page 11 about the various purposes of a pretrial. And again, I wrote in the column, especially with the non-represented litigant. If the other side is not represented, I think that is so important. And that is the pretrial without, a pretrial where one party is not represented. Now, what I mentioned on page 12, I think, is something that I would recommend, and that is, similarly to the rules of procedure, Rule 5008, perhaps it's sophistication that is too sophisticated, I don't know, but I don't see why pretrials cannot be conducted by a conference telephone call if you've got counsels involved. It would save, I think, a lot of time and a lot of money, and particularly where there's a great geographical distance between the parties. There may not be a great geographical distance between where the cause of action arose and where the plaintiff may reside, but there may be a great geographical distance between the parties themselves or the counsel themselves. Another issue I think that you'll find of great importance is the offer to settle, and the Rule 15 with respect to the offer to settle. The real problem, of course, with an offer to settle is making an offer to settle to someone who is not represented. And I would like to be presumptuous because I know my experience with lawyers appearing in court with vis-a-vis the non-represented litigants, that the lawyers in most cases acted in a way that they were being assistant. They were assisting the court. It wasn't an adversarial atmosphere. So certainly there's no reason why, if you make an offer to settle, you might even, in quotation marks, attach Rule 15 or even explain to the unrepresented litigant what the offer to settle means. Again, I think often lawyers acted in a pro se manner in the sense that they were assisting the court, and friends of the court, not simply representing one of the parties. I mentioned the cost consequences of failure to accept an offer to settle, and I won't go into that because that's discussed in the paper. Costs generally, I discussed, of course, costs in the small claims court. Initially at page 19 of the paper, I think that these figures will have to be revised, obviously, because the jurisdiction has been increased. You're aware of Section 29 of the Courts of Justice Act that talks about an award of cost shall not exceed 15% of the amount claimed. There's some question as to how individuals interpret that. Again, we have to keep in mind, quote unquote, that it is the small claims court and to some extent, obviously, still a people's court. I hope, in my mind, that 15% is 15% of 6,000 as a maximum, not 15% of 6,000 plus double the amount in terms of an offer to settle rule. Because if you start awarding $1,800 costs in a $6,000 case, then I think this court loses its purpose to a great extent. I think that has to be clarified in terms of what 15% represents. Does it represent the maximum that you can recover, including all of the costs? Rule 21, Rick Soderberg and will be dealing with this with his panel later on this morning. I simply wanted to point out to you that if you weren't aware that an order of a judge is defined to include a judgment. So if you get an order for cost for $50 or $100 or $200 or whatever it may be, that can be enforced in the same way as a judgment can be enforced. The other point I mentioned on page 20 that some people, my experience is that they were not aware of, is that there is no automatic stay of proceedings, of enforcement proceedings. So that if a judge awards $2,000, $4,000, $6,000 at 10:30 in the morning, then hypothetically at 10:31 that judgment can be enforced. So if you want a stay or you want proceedings to be stayed, then the easiest thing to do would be ask the judge for a 15 or 30-day stay of enforcement proceedings. But there is no automatic stay in proceedings pending an appeal. Again, I won't talk about some of the remedies of the defendant. We're running out of time in any event that I discuss. Beginning at page 27 of the paper, I provide an overview of the rules. And again, I refer to Rule 102, Sub 2 on page 27. By analogy, if the rules are silent, practice shall be determined by analogy to the rules. Again, beginning at page 39, there's a discussion of the pleadings themselves and related matters, dealing with the amendments to pleadings, procedural shortcuts, which I think are very important, the fact that you can apply to shorten or lengthen any time in the rules themselves. And then finally, I suppose, and perhaps to some most importantly, the checklist for cost that I begin discussing on page 41. So hopefully when you review the rules, of course, as well within the context of the Courts of Justice Act and the sections of the Courts of Justice Act to deal with small claims court. Historically, as some of you are aware, there were limitations on the subject matter, the subject matters that could be brought in this court, and basically you don't have the same kinds of limitations anymore that historically took place. Thank you.
Good morning. The next part of our program is going to deal with the pretrial and motion process in the small claims court. Excuse me. For those of you that are familiar with the small claims court process, and especially in metropolitan Toronto, you know that the pretrial process has been a fact of life in metropolitan Toronto for well over 10 years. and probably goes back to when the monetary jurisdiction in Toronto was $1,000 prior to 1980. What we are finding now is that there seems to be a greater emphasis on the pretrial process, especially given the fact that we are now at $6,000. In metropolitan Toronto, which I've mentioned, of course, we have pretrials in most actions, and in scattered areas throughout the province, we've had them for several years. For example, in Hamilton, in East Region, in Ottawa, and many of the smaller small claims court divisions throughout that particular region. Judge Zuker alluded to the fact that pretrials can be requested by a party. I would also say that a judge, even without a request, can have a pretrial institute on any specific action. In Southwest Region, which encompasses small claims courts, I think from Woodstock to Windsor, the senior regional judge has ordered that all small claims court actions will be pre-tried, and hearing officers have been appointed to deal with them. Now, we're not sure of the success factor because this is a relatively new program in Southwest Region. However, I'm quite sure that as these hearing officers become more familiar with the pretrial process, and we're able to gauge the success of the pretrial as part of the dispute mechanism in the small claims court, there may well be an extension of this particular program throughout the small claims courts within the province. With this in mind, it's a pleasure for me to introduce our speaker this morning, the Honorable Ben W. Grossberg, QC, who is a retired judge of the District Court, now the Ontario Court General Division. Mr. Grossberg has been an arbitrator and mediator in commercial and insurance-related disputes, and has also presided over pretrials in small claims court, and if my recollection is correct, Your Honor, I think this is for several years now. And we are extremely fortunate to have him address what is a very important topic in the small claims court process. And without further ado, I'd like to introduce Judge Ben Grossberg.
The program indicates that I was also to speak on motions. When I was called, this was not proposed to me, and I do not intend to direct any comments to motions other than motions at a pre-trial. I do not sit in the court, nor do I hear motions, so I am not qualified to speak on motions that are heard by a motions judge. I have a mild criticism of Judge Zuker's comments in respect to pretrials and what he has in his book. Namely, I do not think that he places sufficient emphasis on the settlement aspect of a pretrial. The small claims court, and I'm only going to speak of the small claims court in metropolitan Toronto, could not function properly or successfully without pretrials. I have been hearing pretrials for some years now. I was asked to do so by the late Judge Turner, and I continued to do so because it is said that when you're a judge, you're quite sanctimonious, but after you retire, you acquire some idealism. I have some idealism about this court. I think the small claims court is an important court in this province. I repeat that the court could not function in metropolitan Toronto without the system. If pretrials were not held in metropolitan Toronto, there would be cases on the trial list which should not be there because settlement has not been explored. There would be cases on the trial list where the claim is frivolous, where the defense is without merit. And at the pretrial level, a pretrial judge can eliminate those cases. If these cases were placed on the trial list, you'd find that the trial judge could not proceed with the case. The defendant is in bankruptcy. The plaintiff is no longer in business. The defendant is no longer in business. These matters are all explored at the pretrial by the pretrial judge. Consequently, only those cases which should be on the trial list ultimately are found to be on the trial list. Also, one finds that many disputes are filed for a delay. I could give you many examples. Unfortunately, I have a limited time, and I want to, as quickly as possible, get to the negotiation aspect of a pretrial. Criticism of the legal justice system is increasing. The system has become much too expensive, and for those particularly of low or moderate income, the system cannot be used. Delay has caused a loss of efficiency, and there is consequent dissatisfaction of litigants. I wish you could hear what is said at a pretrial by some of the litigants. They complain of delay. They complain of costs. When we think that a case that's instituted in this court takes about a year to get to a pretrial, and then after that, it takes probably 6 months before it's put on the trial list, does one wonder that the person who comes into court is dissatisfied? And particularly, unless there is discussion of settlement, the contestation of claims in the small claims court does not in many cases serve the litigant's economic interest. A successful party in a contested lawsuit at a trial in this court may ultimately have an economic loss. I want to give you, pause for a moment to give you some statistics which have been calculated in the 4 Toronto small claims courts. In the month of December 1992, January 1993, and February 1993, 48% of actions not yet listed for trial, but sent to pre-trial and heard by a judge or a deputy judge were settled. The average for a referee was higher. These figures do not reflect settlements which are made between the time of the pretrial and as a result of discussion at the pretrial and the trial itself. Also, these figures do not reflect settlements which are made by a conference when the trial commences by the trial judge. A pretrial, has been said this morning, can be asked. One can ask for a pretrial. In my view, in my experience, and it's some years, as I say, I do not sit in the court. I simply hear pretrials as part of the work that I'm doing. I have rarely found that a litigant asks for a pretrial. Usually, the pretrial is ordered in this manner, that the case management judge looks over the files, and if he thinks it is an appropriate case for a pretrial, he then sends it forward to be heard by a judge, deputy judge, or referee. And as I will mention later, there have been 30 members of the Advocate Society who will be hearing pretrials. And I may say without being paid. Purely idealism, because there is so much dissatisfaction with the system that the Advocate Society has taken upon itself to help the system by having 30 of its members hear pre-trials. That is in addition to 30 of its members who will be hearing small claims cases in the court itself. So you have approximately 60 members of the Advocate Society who have volunteered to help the system. I do not intend to make any distasteful comments about the administration of the Small Claims Court by those responsible, but I think what I have said is a sad commentary on those who are administering the system, that they have to call on lawyers to carry out judicial functions as they are doing. Now, having said that, it's my view that all cases, and I hope that this will come by an amendment to the rules, that all cases above a certain amount should be sent for pretrial. I do not know what criteria the the case management judge adopts when he sends a case forward for pretrial. I do know that some of the judges send all the cases for pretrial. And I would recommend that, and as I will mention later, the necessity of, in my comment about the necessity of amendment to the pretrial of the Small Claims Court rules, that there be pretrials in all cases above a certain amount. The judge who orders the pretrial considers who should hear it. The options are a judge, and that includes a deputy judge, a referee under Rule 22, or a designated person under Rule 1401. These 30 lawyers from the Advocate Society will be designated persons under Rule 1401 who will be hearing pretrials. I have to say that I'm very critical of the use of a designated person. He has no authority to make orders. He or she, I'm sorry. Also, a referee has no authority to make orders. All the referee or the designated person may do is to make a recommendation. That recommendation is then reviewed by a judge of this court. And I have to tell you that if you know the situation in this court, and I hope my figures are reasonably accurate, there were in metropolitan Toronto 12, I believe, full-time judges. That number now has been substantially increased, and from what I understand, it is not intended to appoint any full-time judges to this court, that it is intended to act through deputy judges and persons who are designated. Again, I will not make any distasteful comments about that way of administering justice. That is a matter, I take it, for the those who are administering the act. I have a limited time, and I do want to spend some time on negotiation at the pretrial level. The settlement process is frustrated unless there be adequate preparation. There has to be discussion between the client and the solicitor or the agent about the desirability of exploring settlement and what admissions should be made. It has been said that there are very few cases that do not admit of discussions for settlement. It's frustrating for a pretrial judge or a person conducting the pretrial if there has not been adequate preparation. I have often sensed that the clerk or the student who attends the pretrial has been given the file that morning and told to come to the pretrial, say nothing, and just ask for a date for trial, which of course the pretrial judge cannot give. This is improper training of a student or of a clerk. It puts the trial judge and a pretrial judge in a very difficult position in applying Rule 1401, namely awarding costs for lack of preparation. The student or clerk will have to report back to his principal that he has been assessed costs because of his presentation, and I would think that it might reflect on his continuing in the employment of his office. So I respectfully urge solicitors who send a clerk or a student to a pretrial to adequately train that student as to what a pretrial is and to have the student read and study the art of negotiation. A litigant should be told that settlement of an action at a pretrial is not a sign of weakness. One does not know with certainty what will be the result of a trial, particularly if there are different versions of the parties or of the witnesses. One must understand and realize that that it does not necessarily follow that an opposite party is lying if the version is different from that of the person who is opposing him. People remember differently and observe differently. The lawyer, student, or agent should discuss with the client whether a settlement is in the best interest of a client rather than a confrontation in the courtroom. The economics of the case must be carefully considered. The nuisance value of a case is very important to a litigant, and I urge you, do not be manipulated by your client that the case is a matter of principle. Really, that is spelled M-O-N-E-Y. Particularly in the small claims court, it's of the utmost importance that the economics of a contested claim be considered. A litigant must consider, in addition to weighing the probability of the result, the court costs, time away from work, lawyers or agents' costs, if the lawyer or agent is employed, excuse me, loss of business when away from his business or his work, and of course payment of costs to the opposite side. So those are matters that one should discuss with his client. It's a trite, but it's a nevertheless important observation that a bad settlement can be better than a good lawsuit. You've heard that said many times. So that acceptance of an early loss by negotiation and settlement at a pretrial may often be in the litigant's best interest, and he will be better served. There are very many, in the United States, the negotiation, I preface that by saying that negotiation is an art. In some United States law schools, there is a course on negotiation. Harvard Law School has a summer course. I think it's 10 days or 2 weeks on negotiation. So that one has to remember that, or keep in mind, that negotiation is something that has to be learned. One doesn't acquire negotiation by simply going through the law school and even in his practice unless he or she has been educated in negotiation. It's my view that the client should attend the negotiation, excuse me. And the reason for that is that he hears firsthand the opposite side of the case. Also, he's there to give instructions. It's frustrating when a lawyer or a student comes to a pretrial and says, I've heard what has been said here. I will obtain instructions from my client. Now, that is not a proper way to conduct, to have negotiations at a pretrial. At least the client should be available before you leave for the pretrial hearing on the telephone so that he or she can be telephoned and be asked for instructions and be told of the views of the pretrial judge. It is not helpful at a pretrial to posture, to bluff, and say, for instance, I have no instructions. You should have instructions before you come to the pretrial. You should discuss with the client all the ramifications of the case so that you may, in the client's best interest, settle the case and save the client money in the long run. The client, if he comes, I found this, and I don't deplore this. I think it's probably a matter of economics, that a solicitor will prepare the claim or the defense, and the client will be sent to the pretrial without his solicitor or without his counsel. In such a case, the client should be fully instructed before he attends as to what will be discussed at the pretrial. He should be ready to discuss the case with the opposite side without acrimony and with a view to getting the case settled to his best advantage. I wish I had more time with you to discuss the techniques of negotiation. In the work that I'm doing, in arbitration, negotiation, I can see some very skilled negotiators, and they have learned that negotiation can be an art. Don't bluff. If your client instructs you to explore settlement, say so in appropriate words. Be frank, for instance, and say, my client is interested in a reasonable settlement to avoid the expense and trouble and loss of time by a confrontation at a trial. There are other openings which show willingness to compromise. A technique that I've observed is what we call the percentage technique. That is, the counsel will say, I have, I think, a 50-50 chance of winning. Let's start from there. Or I have a 75% chance of winning. All the literature stresses that negotiations should not start, one should not start negotiations with an unreasonable high figure, or the defendant start with an unreasonably low figure. Isn't it better if each party asks the other, what is your figure for settlement? And negotiate from those figures after discussing the merits. So that, in my view, the primary purpose of a pretrial should be settlement. Of course, as Judge Zuker has said, the pretrial can be used for other purposes. I have some doubt, considerable doubt, as to whether one can entertain a motion, as is said at the, by Judge Zuker at the pretrial. I think one has to give notice to the other side. Our system of justice does not allow you to throw something in the dark. That is, to come to the pretrial and say, I would like this or I would like that. The other side should give, one should give notice of any motion that is to be made. If the case is not to be settled, it cannot be settled, there should be an agreement of facts that are not in dispute. There should be relevant documents produced and exchanged. I do not think that examination for discovery, in my experience of several years, has ever been ordered. And the reason for that is that each side can ask the other questions at the pretrial as if it were as if there was discovery. Therefore, full disclosure should be made at the pretrial. The failure to attend a pretrial. There is no provision in the rules which enables one hearing a pretrial to give a judgment dismissing the action or judgment for the plaintiff if the opposite side does not appear. That's a deficiency in the rules, and I would hope that it would be amended. At a trial, of course, if the opposite side does not appear, there is a rule which permits the court to give judgment. That is not so at a pretrial. And one's experience is that there are many cases where the opposite party does not attend. All that can be done is to impose terms. The order that is made, and not necessarily in these terms, is that the defaulting party pay costs, which I usually assess at $100 or $150, to the party attending. And if those costs are not paid within a specified time, the action is either dismissed or the defense be struck out. Now, you can't dismiss the action, of course, if it is an unliquidated amount. It still has to be placed on the trial list to assess damages. Similarly, if the defendant doesn't attend, if the plaintiff doesn't attend, the action can be dismissed. Now, if those costs are paid into court, a new pretrial is ordered. I have to say that in many cases there are proper and legitimate reasons why the party doesn't appear, namely that he has not received the notice which has been sent by ordinary mail. And it is my practice usually to have the receptionist or someone in the office, if there is a non-attendance, to phone the opposite side and say that it's provincial court speaking. Does anyone intend to appear at the pretrial this morning or this afternoon? And the excuses which are given are often legitimate, namely that, we have received no notice, or we've moved and we have not received the forwarding mail. Also, you can weed out by, if that is done, you can weed out those cases where the dispute has been put in for delay or where the claim is frivolous. I won't go into, if I had time, I would give you examples of frivolous claims and frivolous disputes which are found at a pretrial. If the case is not settled, the judge at the pretrial or the person conducting the pretrial makes a report. That report is a printed form in Metro Toronto. That printed form provides that there be set out a discussion of the issues which the trial judge has to decide. For instance, in a negligence case, the pretrial judge might well say the issues are: one, was the defendant negligent? Was the plaintiff negligent? If both, apportionment of fault, and three, assessment of damages, so that when the trial judge picks that report up, he can attack the case and say that let us get down to the issues in this case. I want to mention a number of factors which I think will be helpful to you. Can a claim which is now $3,000 be increased to $6,000? There's authority followed that the increase can be ordered and that it is a matter of procedure. That case, if you wish to make a note of it, is Johansson versus Williamson, 1978, 18 Interior Reports, 2nd, 585. When those requests are made at a pretrial, when a request of that kind is made at a pretrial, I do not think that pretrial judge should entertain it unless notice has been given to the opposite party that the request will be made. In the same way that I do not think a motion should be entertained unless notice to the opposite party has been given. Of course, that is subject to the discretion of the pretrial judge if he thinks there's no prejudice in hearing the application without notice having been given. So that if you wish to raise the case from 3,000 to between 3 and 6, and wish to withdraw the abandonment in excess of the $3,000, I submit respectfully that that should be by way of motion to the motions judge with proper material indicating there's no prejudice. There's no right of appeal from an interlocutory order made at a pretrial by the pretrial judge. And the decision of the divisional court in that case goes this far. It says that a pretrial judge should not decide a point of law at the pretrial. Now, having said all that, I just wish to spend a few moments as to the small claims court rules. They require some important amendments. Judge Zuker has said that one can turn to the rules of the General Court, of the Interior Court, General Division, if there is no appropriate rule in the small claims court. Judge Zuker's views are always worthy of respect, but I must say that I cannot agree with that. For instance, there's no right in the small claims court to have a cross action. You have to do it by a third party notice. And I do not think that one can, because there is a rule in the General Division that you can proceed by cross action, that you can do so in the small claims court. I think you have to go by third party action. There should be a right to give judgment in an appropriate case at the pretrial level. I heard a case where the defense, a pretrial where the defense was by a contractor, by a subcontractor, against a subcontractor, that he hadn't been paid by the main contractor and therefore he wasn't liable to the plaintiff. Now that's the sort of frivolous defense you sometimes find. In that sort of a case, there should be a right at the pretrial level to say that that is not a legal defense and should be struck out. But there's no right under the rules at the present time for a pretrial judge to give judgment. All he can do is impose terms. So in those cases that are frivolous or where there's a defense manifestly for a delay, cannot be stopped at the pretrial level. One has to put the case on the list for trial in those circumstances. So that these rules, which in my, to my recollection, and I'm subject to correction, were made in 1984 with a slight amendment in 1985, should be completely reviewed, particularly in the light of the raise in jurisdiction. And they should be brought in line with many of the rules of the Interior Court General Division. One has to keep in mind that the Small Claims Court, under the Courts of Justice Act, is a branch of the Interior Court General Division. Now, prior to the raising of jurisdiction from $3,000 to $6,000, if one had a case between $3,000 and $6,000, you could proceed in the Interior Court General Division, and you would apply the rules of that court. Now, if you want to proceed with a case that's above the $3,000 up to the $6,000, you have to go by the rules of the Small Claims Court. Now, there's something illogical about that. And I have in my notes have this to say, that I am pessimistic about the efficiency of the Small Claims Court unless there is the rules are amended, unless there's power given to judges at a pretrial in the same way there is in the Ontario Court General Division, unless there's power to have a cross-action, and in many other respects to conform to the rules of the Ontario Court General Division. And I would, I'm sure Mr. Soderberg has the right to overrule the Minister of Justice and the Deputy Minister, and I would respectfully urge him to have a review of all the Small Claims Court rules to promote the efficiency of justice. Litigants before me are vehement and caustic in their language about the delay in the Small Claims Court. I don't know what can be done about it. The volume of cases, particularly in one jurisdiction which shall be nameless, is so high that that it's going to be a year before those cases can be heard, I'm told, from the time that a pretrial is heard. So that I repeat that this complete system should have a review and be overhauled where necessary. The increase, of course, is desirable, but it brings with it many problems. I've been told that up to now there has not been a very large increase of cases that are being instituted, but that will eventually come. I hope what I've said will be of some assistance to you. I wish I had more time to talk to you about the art of negotiation. There's a considerable literature on negotiation, not only in periodicals, but in textbooks. The Law Society has had, I think, one session of negotiation, but it is an important part of a lawyer's practice, namely that it's in the best interest of his client in many cases, I won't say most cases, that the case be settled and not subject the client to the uncertainties of the courtroom. Thank you.